We're live.
Good morning. It is April 3rd. We are taking back up page 606. We have Joseph Laporto. Am I pronouncing your last name correct? Joseph Laporto from the NRA to share your perspective on page 606. So if you could just introduce yourself, and the floor is also.
Sure, Chair Shin. Thank you for the time this morning. I appreciate the opportunity to come speak with the committee. My name is Joseph Laporto. I'm the State Director for the NRA and cover a portion of New England and including the state of Vermont. So again, I want to thank the committee for the opportunity to speak this morning. I intend to keep my prepared comments on this relatively short. The bill that's in front of us, H606, without some of the amendments that are floating around. We did a fair amount of work on that bill on the House side. Through I think some very positive interactions with the House committee on this bill, I think a lot of our initial concerns on this were addressed. I mean, we in principle object to the necessity for a significant portion of H606 because it is in large part redundant to federal law. So it seems to us an unnecessary step to create state corollaries to what's already federally prohibited, especially as it relates to prohibited persons. We understand at times that states like Vermont have a necessity for creating state companion laws on federal issues because of the necessity of or limited access to federal resources prosecuting crimes. You know, so to the extent that the state of Vermont needs to create and build federal requirements because they need to prosecute these cases in state courts, we can certainly understand that and respect. But at least as far as prohibited person statutes go, those exist under federal law and simultaneously exist under state law without more action from the state. It's just a question of proper reporting to the next database. So you know, if we're primarily concerned with ensuring that firearms don't reach hands that should get them, the federal statute covers the state of Vermont. I think we heard a testimony yesterday from the Public Defender's Office that as far as having a deterrent effect, the likelihood that these laws create that deterrent effect is fairly limited. So while in principle we would oppose a larger percentage of this bill, our concerns as it stands right now on the bill that was passed out of the House is much more narrow and limited. Our concerns really rest in a very limited provision inside of Section 3, and that provision exists on page 7, lines 1 through 3. And in particular, our chief concern with the language of this section relates to the treatment of quote unquote non-hospitalization orders. We recognize under the federal system that it is a long-standing sort of framework for dealing with prohibited persons, and the goal of the policy objective of all of that is to ensure that violent felons are not able to access firearms. We can certainly agree with that concept, and it is well rooted in both federal law and jurisprudence on the Second Amendment. That those have been adjudicated as dangerous, should not have access to firearms, and those are principles we can generally agree upon. The question really, is more about due process standards. And under Vermont law, when we're dealing with mental health issues, there's two sort of paths there. There's a criminal component, which is a much more serious environment where there's higher standards of due process, and then there's a civil track for commitment orders. And what we're talking about in this section deals with fairly low standard civil commitment, where Vermont law currently creates some flexibility for judges to provide for non-hospitalization orders for folks that don't meet the threshold of being a danger to themselves or others, where civil commitment would be appropriate. So by default, if a judge is saying that a non-hospitalization order is appropriate, that respondent has not met the standard to be committed, and that standard is the dangerousness standard. So by default, the decision in that case is that that person is safe to return to society and is now under supervision. So essentially that person is receiving non-outpatient treatment And in many cases, and I actually went and reviewed a series of court cases that have been presented to the appellate courts here in Vermont. There are many instances where, based on the progress of that outpatient treatment, there could be a decision that that person is now, declined and is now in need of hospitalization. So there's supervision over this process. But if somebody's given a non-hospitalization order and outpatient treatment, it's in an environment where the standards on due process are very low. These are civil orders where we're talking about preponderance of evidence or lower type standards of proof. And essentially the court is saying that they're not a danger to themselves or others by virtue of the fact that they've been returned to society, albeit under supervision. We heard testimony from the public defender's office about creating too big a bathtub here. And what Section 3 is doing is trying to create a corollary system to the federal system, which is to say, those who have been committed to, some sort of psychiatric facility, a mental hospital, or prison, right, felons, those people are treated clearly under federal law. There's a big lack of synchronization as it relates to civil non-hospitalization orders. That is our chief concern, and what we view as the big sort of the difference between what the state is proposing to set up as a system versus the federal system. And we think those should be synchronized. Again, there's both due process concerns and the very core principle that I think we also heard testimony yesterday regarding the state of American jurisprudence on the Second Amendment. The most recent case before the Supreme Court was U.S. versus Rahimi, where some of these issues were more squarely dealt with. And yeah, the core holding in Rahimi was that when a court finds that a defendant is a danger to themselves or other, they can be temporarily disarmed, consistent with the Second Amendment. But that, of course, insists on adequate due process, and that was thematic throughout the whole. So the question is, are we dealing with instances where there's an adequate due process? Is the finding an actual dangerousness finding in the case of non-hospitalization, or if that's simply not true? So, as far as Section 3 is concerned, that's our chief concern and the one that we wanted to bring to the committee's attention this morning. Section 4 of the bill, again, we review that as relatively redundant to federal law. It is good in the sense that the definitions there are fully synchronized with federal law as it relates to machine guns. And just to clarify some points that were raised yesterday, I think we heard testimony with regards to auto sears and Glock switches. That's the advantage of tracking the federal definitions, because those devices are treated as machine guns under federal law. So when you're allowed to rely on those ATF technical determinations, then a state prosecutor doesn't have to reinvent the wheel in any given case. You can rely on the federal definition, and you can prosecute that case relying on those technical federal findings. So in those instances, if you create an ambiguous category of things, then the state bears the burden of trying to find what those things are in court. That becomes a factual matter, a jury question. And as a practical matter, it would make that very, very difficult to prosecute. Under this framework, gun owners are safer because, we have one common framework between the state and federal government. So, we're not in some gray area where we don't know whether or not we're trying to comply with the law, but don't know whether in fact we are. Now there's that sort of clear definition and framework, but it's also now relatively easy to prosecute if you're dealing with some of the violent crime issues that major cities like Chicago are dealing with, where, not only are these Glock switches proliferating, they're being used pretty consistently in crime as an issue. And we would recognize it's an issue. And the lack of federal resources is an issue. So again, we understand the necessity for it, but make the task easier to prosecute. Under federal law, possessing one of those 3D printed Glock switches that we heard testimony on yesterday, that's a 10-year felony and a potentially $250,000 fine under federal law. And it's a stackable offense. So if I'm trafficking a Glock switches illegally and I've got 5 of them in my pocket, I'm facing possibly 50 years in jail for that. It's a stiffer penalty than murder in most cases. So it's serious offense, but it is the pathway that we, reached in H 606 that relates to that issue, and it addresses the actual problem and makes it relatively easy for the state to take action on itself. And it protects veterans in the sense that they're essentially no worse off under federal law or state law here. So there's a synchronization there that ensures that we've got a level playing field between the state and federal government. So, sections 1 and 2, we almost no opposition to in the first instance. To the extent that the state is here, addressing bad behavior, bad conduct, and criminal conduct. I mean, the NRA and our members have no interest in weighing in on that process. The state should pursue avenues to enforce the law and fight crime, quite frankly. And I think at the heart of this is essentially a crime bill with some of these minor corrections here. I will speak briefly to the amendments, and I would like to sort of frame my testimony on those. As a starting point, I would sort of like to reserve the option to revise our opinion on those matters, because we still don't quite know what we're dealing with on some of the amendments. We haven't had an adequate amount of time to review and address those. We saw and heard some testimony yesterday regarding the relinquishment of issues, surrendering of firearms, essentially a custody of firearms issue which relates to both domestic violence restraining orders and extreme risk protection orders. I think at the heart of that, the policy goal here is to create more resources for the state by creating partnerships with FFLs. I think that's possibly a good goal. We just have not had an opportunity to really work through the details on that. And I think the state is in need of a good solution here. I mean, we're essentially trying to bootstrap private resources onto the state government to fill needs that are currently not being met. I mean, I wonder about the sort of the idea there, like, should not the state just provide those resources? But I guess that's another question. But to the extent that there's a need for a partnership, with the bills, I think more work needs to be done on that bill. There are some concerns just at first blush as we look through the language of it, but it's in such rough form, and we've gotten so little feedback from industry on that. I just don't know what, if anything, we can truly object to or discuss in a meaningful way in this session. So,
you did mention you had a couple of things at first blush, and understandably you'd like to work on those more. Can you just give us the areas that
I mean, first blush, I think this bill, as I understand, and as we look at the issue, essentially what we're saying here is there's a need that's not being met from law enforcement with respect to storing firearms. And so what we're trying to do is find essentially private alternatives to that, whether that's through FFLs or in some cases through third parties. There's nothing in this bill that guarantees that FFLs are going to want to participate or have an interest in participating. But Vermont, since this legislation was first enacted, had a mechanism where third parties could be designated. And it seems like some of the provisions would make it much harder for a third party to be designated as a custodian for those surrendered firearms. I believe that there's language in that bill that would change the current law to prevent courts from granting a continuance. And this is just one example, right? But I think there's a provision in the bill as written that would prevent the courts from granting a continuance if they could bring an adequate third party before the court for approval. I mean, what's the policy goal there, right? If the court's trying to find a solution for that, and the respondent needs an extra day to present the third party to the court, why prevent those things from happening? I mean, again, this is just a cursory review that we've had overnight, just looking at the text of the bill. I mean, quite frankly, there was a report on this issue back in November, and there's been a placeholder bill since the start of the session with no text. If this is an important issue, then we should have seen the text of this bill at the start of the session, and we would have had time to address the issue thoroughly and properly. And again, to the extent that as someone representing the association, the National Rifle Association, our concern is our members. We certainly do at times weigh in on issues that affect the firearms industry itself, but we're not a direct representative of industry in any actual way. That's not our primary objective. Having said that, we work with our counterparts that represent that industry. They are a major constituent in that legislation, and unfortunately, as it stands right now, they're by and large silent on it. I know that there's testimony that they spoke to a handful of dealers around the state, but I think if you're trying to craft a viable policy and solution here, you need more deliberation, more discussion, more interaction with the industry to try and partner with. So I really think the issues with that bill is just it's too rough and too rushed. You know, if we had the whole session to work on it, might be a different story. But I think this is too little, too late from our point of view, and it's difficult to opine on it in this morning session because it is a complex issue.
Yeah, just so you know, this isn't a bill that we're going to be rushing through by any means. It's going to take at a minimum a few weeks. So
yeah,
I know you're mentioning that the whole session to work on it, but you and other folks will have opportunity to testify additional comments based on how the bill is going, or just make the request and you're welcome to come back. And that same invitation is open to other folks as well who have different perspectives on this bill.
We welcome that opportunity.
There was one point I wanted to go back to page 7 regarding the ONHs. I didn't quite. I understand your due process concerns, but I don't quite understand the idea that people who are under ONHs aren't threats to themselves or others, because if we're to get an ONH, the court does have to find that you're a danger to yourself or to others.
If you look at how this played out in case law, you know, it is there's a very, very clear standard for someone who could be hospitalized under that. And there are very clear definitions as to what it means to be that threshold that you have to be in fact danger, imminent danger to yourself or others. The fact that you're in need of help, you know, again, a non-hospitalization order is an outpatient treatment system. And so just as a matter of, as a principle, there's no conceivable way that, you know, you can meet that high standard for being an imminent threat to yourself or others and simultaneously being returned to the street. So
I don't think it's imminent. I'm not trying to split here. I don't think it's imminent. I'm looking at the federal language and what we had in 4822. I don't believe is it an imminent?
I think danger to self or others, which does cover 7617B3, which is what the references being made to on page 7.
It is
danger to self or others. Yeah. So if you look at page 7, line 3, that's a non-hospitalization piece of it. In either case, the court has to find before the ONH that the person's a person in need of treatment.
Yeah.
I'm not positive about the word imminent, but we just don't.
I was just curious on that one, but so for the federal language, if somebody is adjudicated as a danger to themselves or others, and they're a prohibited person, is that same person also physically committed to a locked and secured facility?
that generally the federal system recognizes that way. Let's discuss some of the other scenarios. If I'm a criminal defendant and I'm found not guilty by reason of insanity, that falls under the general category of being adjudicated, you know, mentally defective using the federal parlance, you know, federal language. But there's an actual adjudication there. And obviously commitments to a psychiatric facility, if you've been committed either criminally or civilly, that commitment order is supposed to be transmitted to NICS. And at that point, you know, the respondent, you know, can at some point seek, they can get that record removed through a legal proceeding. But those are proper transmissions to NICS. And part of the concern right now is that these non-hospitalization orders are under current Vermont law are being transmitted to NICS, and that's technically inappropriate. The way the federal NICS system works, practice is the federal system creates a series of categories for folks that are prohibited under federal law. But that list of categories also includes anyone who is prohibited under a given state law. So the federal list includes all things that are federally prohibited, plus anything the state says is a prohibition. And at that point, the NICS system can then collect those records. So in other words, being convicted of a violent felony doesn't require state law. The federal law covers it. It's just a matter of the state transmitting the records to NICS that's properly tracked in the federal database. So that it goes to the Federal Bureau of Identification property. The feds are technically supposed to, if the state is transmitting records that are neither federally prohibited or specifically prohibited under state law, and without the passage of H 606, right now, Vermont state law doesn't provide a corollary, and that's partly why we're here, to sort of create that framework. But currently, Vermont state law is silent on this issue. Nonetheless, the language of the existing health law says that those records should be transmitted to NICS. So they're already going to the NICS database. Now, in practice, the federal government is supposed to screen those out. But in reality, there's no mechanism for the federal government to filter records being transmitted by the state. So unfortunately, in reality, the state of Vermont can transmit whatever records it wants, whether they're appropriate or not. And there's really no mechanism to screen those out of the NICS database. So again, the problem here is that, if this was just simply a matter of, and I think we heard testimony on this all the way through, the framework here is meant to restrain conduct while the order is in effect. So in other words, under the way Vermont is handling this, under Vermont law, the moment that those orders expire, the person is no longer prohibited. The problem is you transmitted those records to NICS, so now they're federally in the database, and now they've got a legal problem that they've got to deal with. And that can be very, very costly. So getting an expungement requires legal procedures that folks have to pay for. And if we have indeed created too big a bathtub here, we're now making them felons under Vermont law because of the fact that they are potentially possessing firearms that may or may not be covered under federal law. And so they run the risk of enforcement under this. And in addition, at best, they have to pay a pretty heavy fee in order to restore their rights when they don't immediately fall into that category. So that's our chief concern with section 3.
Okay. Thank you. Any questions?
I just want to, the metaphor too big a bathtub, I can't go along with, because a bath is a good thing. So like, sounds like if we use that, I would prefer like too big a net, because you're getting crowded in that.
Probably
a bathtub.
Probably a better analogy.
People are
Wasn't my
cleaning
analogy. I just borrowed the analogy from Justin. I probably would use her net analogy.
Yeah.
Before I part, I would just briefly say on the proposed amendment with regards to banning the possession of firearms in facilities that serve alcohol. That's a policy that we just wholeheartedly, full-throated oppose. I mean, restrict again, too big a net. We'll change the analogy. Too big a net. There's the presumption that folks go to places that serve alcohol simply and only for the purpose of getting intoxicated is simply rather than reality. The vast majority of places that serve alcohol serve food, they serve breakfast, they're hotels, they're all sorts of places that folks are routinely going to for all sorts of reasons. And they cover large swaths of the sort of heart section of our communities, and there's no real good argument for wholesale declaring those places gun-free zones. They're not secured. There's no reason to expect additional security in a bar. If anything, if we're concerned about conduct in bars, there's more reason to think that you might be the victim of the crime in the bar. So this is another area where we're conflating an environment with conduct. If the focus of legislation was on conduct, i.e., should you be heavily intoxicated while carrying a firearm? I mean, that's another matter, and that would be, it's more difficult sort of issue to address. And from our perspective, we're not here to defend reckless conduct. But simply going to a restaurant on Sunday for dinner with my family and where I intend to consume no alcohol and I'm expected to be defenseless in that environment simply because that place serves alcohol to some patrons. That's just a poor policy. And that is an issue that we are litigating over in multiple states. It is, we heard some discussion yesterday from the solicitor on the constitutionality of 606 in its present form. Those types of sensitive place designations are a hotly contested area of the law right now. We have lawsuits running in dozens of states at this point on that exact issue. And those are issues that are before the Supreme Court right now. So what's consistent with the nation's history and tradition of firearms regulation? If you look at the sort of core areas that are genuinely accepted by courts across while there's lots of contested territory, the common themes are places like polling places and courthouses and legislatures. Those were areas that were designated as sensitive at the time of founding. The reason why they were designated as sensitive is because they were places where core, democratic functions are occurring, political functions are occurring, and they were secured by the government. There's a presumption of security in courthouses. There are bailiffs and sheriffs in a legislature, sheriff at arms, and we've got security in legislatures. Similarly, in polling places, there's generally a presumption of security from the local sheriff. So the places that are consistent with the founding as it relates to sensitive place laws are places where the government is providing that extra security. There's a presumption that that's the case. If we start declaring every place under the sun as a sensitive location, despite the fact that there's no actual security or resources to provide for the security of people that are there, that is entirely inconsistent with the nation's tradition. So,
Would you feel that way about schools?
Schools are a tough issue,
But it would seem your argument wholesale applies to schools as well.
I would say, schools are one of those areas again that we're wrestling with. And it really comes down to, again, the question of what burdens the state have in ensuring security in those places.
In the founding.
Yeah.
See, that's where I take issue with, Justice Thomas, his opinion. I fully understand that in certain ways, you can look back 300 years ago or 250 years ago and get useful guidance. But I think in many ways, you can't get useful guidance about, what is now a 21st century country with, hundreds of millions more people. So something like schools, we're in an epidemic of school shootings. And I know that there's a difference of opinion about how to respond to that. Some people make the argument that more guns in the school zone would produce less violence or less death. I don't happen to believe that myself. So, we passed a ban on paramilitary training camps.
Hold on, sorry. In the interest of time, because we do have two other witnesses, is it possible to keep it contained to the amendment in the bill that we have? And then we can have.
I'm happy to discuss that issue.
Okay.
And I do have one question, and then Senator Mahosky.
Sure.
You had mentioned intoxicated persons earlier. Would you be supportive or perhaps neutral on a prohibition on being intoxicated while carrying a firearm?
To the extent that was carefully crafted, it's more likely we'd be neutral on that issue. I mean, we're unlikely to go and shepherd legislation like that through a state house, but again, as it relates to reckless conduct, there's nothing to defend there from our perspective. We're here to defend the rights of law-abiding people, peaceful people, not those who engage in dangerous conduct. So we'd have to see the text of it, but it's very likely we'd be neutral on that issue. Senator Mahosky.
I appreciate that, but I do want to just from a brain science standpoint, point out that there's actually no amount of alcohol that doesn't affect your judgment. So I don't really think there's any amount of alcohol in guns that we should be mixing. My question for you is if you were aware that in October of 2024, the Second Circuit actually upheld in Antoinette versus James that you can prohibit firearms in places that serve alcohol, and that they cited historical analogs from 1853 in New Mexico when they prohibited firearms at balls and fandangos. In 1870 in San Antonio, Texas, they banned firearms in any bar, room, or drinking saloon. In 1879, New Orleans banned firearms at any public hall or tavern. In 1889, Arizona required that the keepers of drinking saloons keep posted up in a conspicuous place in his bar room a plain notice to travelers to divest themselves of their weapons. There's actually a pretty lengthy list of historical analogs to banning.
Every single one of those that he mentioned has come well after the 1868 reference period. So if we want to discuss.
New Mexico's not 1853, so that is chronologically before 1868.
Yeah, well, one of the major questions before the Supreme Court this term is the question of this decision between 1791 and 1868. And that is an issue that is likely going to be settled here. The principle that seems to be evolving across multiple circuits, including the Third Circuit, which said this a little bit more clearly, is that the true reference period is 1791. And you should merely look to 1868 as confirmed confirmation of a tradition from 1791. Now, the issue that you're raising, yeah, the Second Circuit has ruled the way that they have. That issue is also before the Third Circuit, the Fourth Circuit, the Ninth Circuit, and some of those sensitive place issues are now before the Supreme Court. So it is an evolving area of jurisprudence. And while the Second Circuit is a panel decision of the Second Circuit on a preliminary interlocutory case, preliminary injunction, I don't think that's dispositive on what the end result of the law is going to be on this issue. Again, it's on behalf of the NRA, we're litigating, north of 60 cases across the United States and every state and circuit that matters on this issue. So the final say on the matter is going to be the Supreme Court. But these are questions that have evolved out of the Brewing decision. So unfortunately, it's going to take us a couple of years to get there. But that is a fairly disputed issue across circuits, and we'll see as the case law evolves. But the question will hopefully be more fully addressed by the court in the coming sessions. So,
Thank you.
thank you.
Any other questions? Okay, thank you.
Thank you.
The record, Chris Bradley, President of the Vermont Federation of Sportsmen's Clubs. I have the honor of representing approximately 45 clubs across the great state of Vermont with approximately 14,000 members. I have at least concerning the core of 606, so I can be very brief. Section 1, amending 13 VSA 2501. We have no objection to this section. As a point of consideration, however, we foresee a situation where the state prosecutor criminal steals a firearm under the proposed amendment to 13 VSA 2501, while at the same time the state could possibly prosecute the victim of that theft under 13 VSA 4024 damage storage. Certainly there can be situations where things are stolen that you don't immediately understand are stolen. So if we're now after the fact saying, hey, this was stolen, it may very well be that we can't go back and say, what was the criminal against the victim? That's the one. So we suggest that an amendment be considered for 13 VSA 2501, the suggested verbiage being similar to charging a person under this section will disallow the victim of the theft from being prosecuted under 13 VSA 4024. Regarding section 2, 13 VSA 417, no objection to the section. Section 3, amended 13 VSA 4017A. I think my colleague Joe did a very good job of explaining that. We are concerned with the second part of 5C, which states for a non-hospitalization order issued by the court pursuant to 18 VSA 7617B3. The 18 U.S.C. 922 G4 bars possession by individuals who are adjudicated as having a mental defect or who have been admitted to a mental institution. Historically, both the ATF and federal courts interpret committed to mean formal and voluntary commitment, not non-hospitalization or outpatient therapy. Further, firearms prohibitions for prohibited people focus on people who are dangerous or confined, not people who are allowed to live in the community who may be under treatment. If in fact there was a concern that a person was at risk of doing harm to themselves or others, we have a law for that. It's extreme risk protection law. So we seem to be in the middle ground where we're not at purple stage. We didn't commit them. They're not insane. So we're going to release them into the community, but even for outpatient treatment. Now, just as a backdrop, as Joe related, Title 18 says that when somebody happens to be non-hospitalized, we are going to report them to NICS. Once they're reported to NICS, they are not going to be able to buy a firearm until it's expunged or resolved. Interestingly enough, though, any firearms that they may have at home or otherwise are not touched at all in a non-hospitalization situation.
Chris, can
Yes, sir.
I interrupt real quick here? Just want to make sure there's the distinction with ERPO where, if I'm remembering it correctly, with an ERPO, firearm can be seized.
Yes, sir.
Whereas with what's being proposed in this bill, it is sending the report to NICS saying if this person attempts to purchase firearms, they can't do so.
Correct.
But there is no
There's no
process in which, right, so just want to make sure there's a distinction there.
Well, we're essentially releasing somebody under non-hospitalization that they very well have firearms at home that nothing is being done about. Not that I'm necessarily suggesting that, but we have ERPO for a reason. And we are in a situation where if you're not in these other categories, we're in this middle, okay, we can let you in the community. That seems kind of incongruous. Further questions on that? Let's see. Sorry. Section 4, we worked very hard in Section 4, and we have no objective in that section. As far as firearm relinquishment amendment, that we have mentioned 20 DSA 0.07. In the interest of full disclosure, I was invited to serve as a consultant to the Firearms Relinquishment Study Group, and I provided written testimony and was invited to speak and participate with that group once. After giving input, while the Federation was given a copy of the proposed language this past Tuesday, our input was never sought on the language that is now being proposed. As we understand it, the final report was delivered in November. Early in the session, we noted 571, H571, but it was only in short form. At some point after that, and while 606 was being worked on in the House Judiciary, we were provided with a full version of 571. We were told that 571 would likely be amended into H606 by that committee. In reviewing the version I was provided with, I immediately contacted Chairman Long because the submitted bill had missed a substantial part of relinquishment in that neither the report nor the newly minted bill addressed ERPO. This occurred despite my written testimony to the study committee and my specifically mentioning that both DB and ERPO should be addressed when I was asked to speak to the committee. I believe it is for that reason that this amendment did not make it into discussion of H606. And I have to ask the question, if the need for this bill or amendment was so dire, how did it miss one entire section of law relating to relinquishment? And where was it across the earlier part of this session, such that it could have been at least somewhat vetted prior to landing? We do understand, and we do agree, that there needs to be a uniform process to handle the relinquishment of firearms. We also understand that with a recent change to temporary RFAs and DB situations, which now allow for an ex parte defendant to be required to relinquish their firearms, coupled with recent changes to DD forms, which are now heavily focused on whether or not the defendant has firearms or not, and with revoking it will increase the number of firearms that are forced to be relinquished. We understand that most law enforcement do not have the facilities to store firearms, and that there is a reliance on FFLs to take up the storage burden, with 8 currently listed FFLs out of the 340 FFLs in the state are registered in Vermont with the ATF. As an aside here, there were 3,200 RFA petitions filed in 2024. Of those, 1,069 were immediately dismissed, leaving 2,131 where temporary orders were granted. Well, not all of those 2,131 defendants likely had firearms. That could possibly potentially be 2,131 relinquishments. Of those 2,131 temporary orders that may have resulted in relinquishments, over one half apparently should not have had their firearms relinquished, as they never made it to a final hearing. When 20 VSA 2307 became law, the Federation heavily participated in its creation with Chair Sears. And one of the things we were insistent upon was that beyond law enforcement and FSLs being able to store relinquished firearms, there must be a third-party alternative. In criminal law, a third party can become involved as early as the temporary hearing. That has now been removed in favor of forcing a separate hearing for the third party, something that can only cause delays and further burden the court's docket. Further, law enforcement and FFLs have been given immunity. There is no immunity for a third party in this bill. We are not aware, and we ask the AG's office for clarification as to any data where about third party storage, where there has been difficulties in the third party apparently illegally releasing firearms to the opposed defendant. It is a fact that all firearms have value, that some firearms are very expensive, with expensive attachments like slopes, that many firearms have intrinsic emotional value because of his fathers or grandfathers. For someone like me, who is a moderate collector, someone coming to my house to pick up my firearms that I may have been ordered to relinquish would be faced with a daunting task. It would not be appropriate to stack firearms in gun cases or padding into the trunk or the backseat of a cruiser for transport. And what do we do if a situation is encountered where guns are locked in a safe? The study group doesn't touch this. What would be done when there's a discrepancy between the purported victim and the accused over who owns what weapons? Or do we err on the side of caution and take all of them, leaving the defendant defenseless? Per current guidelines on the DPS firearm relinquishment page, it speaks to how the sale of firearms should proceed, with the owner getting any leftover money after all storage fees are settled. This amendment, however, changes that, allowing LE or FFL, mentioning the third party, to retain all proceeds in the sale of a gun. Again, with no provision for the third party. In regard to the 8 FFLs listed as storage sites on the DPS webpage, I tried to contact each one yesterday. I will absolutely no longer do this. Will absolutely no longer do this due to being sued, handling firearms in a DD case that was ultimately dismissed. That would be Green Mountain Sporting Goods. They're not going to handle this anymore. One FFL was out of business. We're down to 6. 2 did not answer their phone. 2 of the FFLs were shops for the sole proprietor, with both having limited storage available. One stated he could not handle storage for someone with more than 10 long guns. Ideally, the state should look to build or create a firearm storage facility. That is, that would be a fiscal expenditure that we likely cannot afford for the near term. A very viable alternative would be to actively promote third party storage, not discourage it. The Federation stands ready to help assist in correcting this possible bill. With the complete mishandling of a third party solution across numerous sections of this bill, in addition to other problems, some of which we simply have not had time to fully outline, will require a great deal of time and possibly other working groups to resolve. We oppose this amendment as not providing the best solution to a very complex problem. We further request that the Attorney General's office be allowed to review this amendment as well as the guns and bar amendment should that stay alive. And we further respectfully request that we bring in a knowledgeable FFL like Henry Carroll, as well as consider asking the NSSF, the National Sports Shooting Foundation, to give testimony, which is an organization that represents the gun industry and FFLs. Just one typo, I think on page 2, line 16, you're referencing subdivision 2, or I believe that should be subdivision 1. Any questions on my testimony on that subject?
One question. So admittedly, I'm still working through the language of the original bill that we got.
Yes, sir.
Trying to fully understand that.
So,
And then the next step is looking at these amendments here more in depth. I noticed you had mentioned ERBOs should be addressed. I think this was at the beginning of your testimony. I'm looking at the first page of the proposed amendment, line 19, and there's new language that's adding ERBOs. I'm assuming there's something that I'm missing, or
this is, I'm sorry, which, referencing
the draft 1.2.
I have 1.1, what section was it?
Line 19, it's under the definitions where it says that it's under the relinquishment definition. Person is required to relinquish firearms or other weapons in the person's possession by court order. It cites the court order and then refers
It does reference extremist protection orders, and 571 is originally released, which I assume this is based on.
571.
It does not have ERBO on it. So what was presented to House Judiciary and to me in consideration of adding it to 606 had no mention of ERBO, correct?
I don't know what was presented to you, but yeah, I agree. Eric Fitzpatrick, Office of Legislative Counsel, that the ERPO edition was made more recent.
Thank you.
Yep.
Could that's your question?
Yes. So the draft that I have is 1.2, just published on the 31st. So if that's
It now addresses, I do, yes, it now addresses the that's the question.
so, I think, and again, there'll be opportunity to talk about it again once you've got the most recent language. But just wanted to clarify that piece regarding the ERPOs. Any other questions, Ruth?
Not a question, but a correction. I noticed you stopped on the number. I gave an inaccurate number because I was including all the federal licenses, but not the dealers. The dealers are.
Dealers are an expansive list of significant classes and categories. I did it last night. It was 345. That's just to clarify.
Yeah, I was looking at the total federal licenses.
Oh, okay. That's we're still here for Vermont specifically.
Well, within Vermont, I was including like manufacturers, collectors, other.
Well, that would be within 345.
Okay, not what I got, but
I can share.
Yeah, sure.
My reference. And as you may be aware, I have gone through the extensive list of FFL sorting out manufacturers with a specific goal of splitting off people that are individuals. They have no storefront. As specifically as in my line of work, I want to know storefronts where these transactions are really happening. Arrows, R&L archery, powder horn, not necessarily the kitchen table FFLs that are allowed to sell firearms. So that would be the big secret.
okay.
I'm sorry.
Oh, no, just dealing with logistics.
Bans on firearms and establishments itself, never again, I apologize. I did look for the language last night. Did not find it. I assume moving forward, based on the comment yesterday, said that we would, thank you. That's what there could be fairly based on, no kinds of bars.
Very, almost identical to what we, passed out in the charter and then was put into H 45, I believe, in the House.
I don't know, it's age 45 in the House, and it was, that's 231 in the Senate as it moved through Senate government House.
Oh, that's 131.
131.
The charter, sorry, I was
Oh, I
thinking we had a state line. I was confused.
Very simple.
We don't have a state line down here.
But I can speak generally to that.
We were drafting that one when I decided to try to do that.
Second law would be a sensitive place statute, and we strongly oppose that idea. As a side note here, we should be aware of H 45, and Bill submitted very early last September that called for creating a line of housing by the statewide. For the record, that bill was so highly valued that it was never even introduced in the House Judiciary. And we conjecture that this was because it was in a sensitive place. We all know or should know that the United States Supreme Court has opined that there are indeed sensitive places, and they were even listed, courts, legislators, and polling places. If I may intercede here, you mentioned schools. Historically, back at the time of Ellen, sent their children away to a school to be educated. The court's reference to no guns in schools apply not to the professors, not to the administration, but the kids could not bring guns to schools. It was not a blanket no guns in schools. It was designed specifically for the kids that were at those schools. We believe this notice specifically listed those places because in each, the government provided security. Courts and legislators have on-site police, and historically sheriffs guarded polling places. In the absence of government-provided security, or security provided by another source utilizing screening equipment, performing bag checks, and having requisite security guards, citizens coming and going to a place designated as a sensitive place where firearms are not allowed have no protection at all. The McDonald decision made it very clear that you could carry legally outside of the home. We believe we understand that, with the noted exception of two fairly recent shootings in Burlington that happened outside of bars. We are not aware of other shootings or any significant number of them that have occurred in Vermont bars. A no guns in bars statute would affect far more than bars. It would affect the restaurants. It would affect hotels. It would possibly make exceptions for other venues that serve alcohol, such as outdoor weddings and parties. Should such a bill use the term premise? According to the definition of premise I find in the state statute, that would extend to parking lots. Please consider a young woman that worked at a bar at Burlington, and she carries home her tips that night. She has no means to defend herself in a city that is experiencing violent crime. Consider a father who is adopted and who is opted to use his constitutional right to carry a firearm for the defense of himself and his family, and he wishes to take his family out to a restaurant for a meal with none of them drinking alcohol. Does he use the right to defense when no other means of defense is provided, not only in the restaurant, but also as they come and go? Consider a businessman who services an ATM in a liquor establishment that serves alcohol, who routinely carries thousands of dollars and also carries a firearm for self-defense. What is he supposed to do? Leave the firearm in his vehicle? And if that vehicle is in the parking lot, he's still at risk. If this amendment is to be accepted into this bill, the Federation respective requests will be given a chance to review the language. Thank you. And then be given the opportunity to provide further pointed testimony against it. In summary, the proposed section amendment bill, we believe we understand that our governor has already indicated he would veto such a bill if it ever made it through his desk. Any questions for me? About half an hour.
Yeah, perfect. So I was able to get I believe we got Tim pushed back like 20 or 30 minutes, and I want to make sure that they just have at least 20 or 30 minutes for today. But if there are any quick questions before.
Not a question, but just a comment. Based on your last comment, there have been times in the past where the governor has threatened to veto and then allowed something to become law or signed it. And that should be done.
Very good. Thank you, sir.
Thank you.
Thank you very much, Mayor. I really appreciate the point.
Thanks. Eric, can you hear us all right?
Yeah, good morning. Can you hear me?
Morning, yes.
Yeah, good. Yeah, sorry. Good morning. Thanks for having us today. My name is Eric Davis. I'm the president of the Gun Owners of Vermont, and we are an all-volunteer nonprofit advocacy group dedicated to the preservation of the right to keep and bear arms. I apologize I couldn't be there in person today. I had to attend over Zoom, and my internet connection is sometimes a little shaky up here in the woods. So hopefully everything stays good, and I don't miss any parts of my testimony here. But I'd like to start off my remarks today with sort of a preamble, and that's that we believe, first and foremost, that the proper function of government is to protect individual rights, and that this principle should not be compromised. The nature of the Second Amendment is that it specifically protects the right of self-defense by guaranteeing that government may not interfere with the ability to acquire the necessary tools with which to defend oneself. Self-defense, as a human right, is an axiom. It's a given. Nobody contests the idea that you have the right to defend yourself against aggression and malice. The premise on which the Second Amendment is built is that the right to defend oneself against aggression and malice is no right at all unless one has protected access to the means with which to do so. And in modern times, that means access to a firearm. That also means that any attempt to restrict access to firearms for anyone is by nature a violation of that person's rights and subsequently a violation of Article 16 and Second Amendment. And we oppose the entire proposal on this principle alone, regardless of any discussion of the specific details or merits of the bill. That said, our testimony today is going to focus mostly on sections 1 and 3, and I'd like to share a few thoughts today about the philosophy behind these kinds of proposals and what we see as sort of fundamental flaws in the approach that's being taken on these issues. In section 1, regarding making it a felony to steal a firearm, we would start by asking the committee and anyone following along to sort of consider a few things. And first, the thing that we'd like folks to consider is, what is it about the crime of larceny that gets so exceptionally worse to be subject to stiffer punishments just because the object stolen was a firearm? What is it about any crime, for that matter, that makes it more nefarious because it occurred with a firearm? Why are guns being given special consideration? Now, in a usual scenario, if you have a bad crime, then most people will look at it and say, oh my goodness, that was a terrible crime and we should hold that person accountable. But we have this strange thing where if a crime happens with a gun, everybody looks and say, oh my goodness, we need to do something about the guns. And by framing the discussion to focus on the device, the gun, rather than the behavior, and in this case, the behavior is the crime of theft, this approach sidesteps several larger issues. For instance, what is it about the crime of theft, or excuse me, what is it about the theft of an item with a value of $899 versus an item valued at $900 that puts an individual into this special group of criminals who can no longer be trusted with a gun? No reasonable person would argue that $1 should be the difference between normal punitive measures and having your constitutional rights revoked. Instead of taking measures to address the inconsistencies in the law, this bill proposes to take more rights away from more people based on the same flawed premises. And once again, the Second Amendment ends up as the proverbial black sheep of the Bill of Rights, in the sense that it is the only constitutional right that you lose effectively forever if you cross this line. You don't lose your right to go speak and worship freely. You don't lose your right to due process, no matter how bad you mess up. Even a convicted serial murderer has a right to a fair trial. And in Vermont, we make sure that you don't even lose your right to vote. But when it comes to the right to keep and bear arms, a mistake made as a young person can haunt an individual for decades after they have atoned for their sins and paid their debt to society. I personally know several people who've made mistakes in their youth, which at the time were considered bad enough to lump them into the legal basket of felonry. I have a longtime friend who stole a lawnmower in his early 20s, which was valued at over $900, and it earned him a felony to which this state prohibits him from hunting with anything other than a black powder rifle. Guy's in his 50s now. I have a family member who ran afoul of the regulatory system 30-something years ago for growing and selling cannabis, which isn't much of a big deal these days. If you go get some paperwork from the state, nobody really cares. They encourage it to a certain extent. He still can't own a gun for his personal protection. I know someone who embezzled money from a business as a young person and paid for it with jail time and reparations. They admitted their mistake years ago, paid their debt to society and the victim, asked for forgiveness, and still cannot buy a gun to this day. And even a young man I knew as a childhood friend who at 18 years old, being a stupid kid, actually stole a gun. And long story short, this guy got in a whole bunch of trouble, but he turned his life around afterwards. He took care of his legal problems. He stopped drinking. He got a good job that wouldn't have been available to him if he caught a felony for the gun thing. And in the 25 years since that incident, he's been a good man, a good father, and a good member of the community. He's a model citizen. If the proper role of government is to protect rights, then lawmakers should first focus on restorative justice and a path to redemption for these folks and others who have made mistakes and paid for them, rather than seeking out more reasons to take rights away. All that said, we do understand that there are some individuals in our society who are very unwell, either psychologically or behaviorally, to the extent where it is the duty of the government to intervene. The issue at the heart of any judicial debate is at what point that intervention is justified. Section 3 attempts to address this issue, but like Section 1, we think it comes up short under a wider scrutiny. If we believe that the proper role of government is to protect rights, we must also accept that part of that duty is to maintain a system of courts and laws with the protection of rights as its core principle. That also means that the government is justified in using force to restrain those who violate the individual rights of others, i.e., maintaining a system of punitive justice and/or treatment for those who offend. For those who do threaten the rights of others, and do so to the extent that they cannot be trusted with guns, or presumably knives or arrows or sharp sticks, we must first ask one very important fundamental question. If this person is so dangerous, why are they out walking around unsupervised? Removing a person's right to self-defense because a court determined that they are suffering from a mental illness and therefore are not responsible enough to have a weapon, and then subsequently kicking them out onto the street to fend for themselves while they are still suffering, is a cruel approach to justice, and it will drive more people away from seeking treatment. One of the largest demographics of gun owners across the country are veterans. People who fought under the American flag and the Constitution for which it stands. People who believe fiercely in the right to keep and bear arms. People who have been mistreated by their government. People who have learned to be deeply distrustful of the systems set up to protect them. These people bear the scars of war and suffer daily from them. And these people will be less likely to seek the help that they need and deserve because their rights are not being protected. And it won't just be the veterans who shy away from the help they need. It'll be people suffering from depression and anxiety, or even anyone just going through a hard time dealing with the emotional and psychological stresses of trying to keep up with life. We've said it for years. Focus on the individual behavior and how to treat it. Focus on mental health and how to treat it. Focus on getting people the resources they need so they can work through their difficulties. Focus on protecting everyone's rights. But for goodness sake, stop with the fanatical obsession of focusing on guns and how to take them away from more people. In closing, I'd like to point out the divide between constituents and lawmakers seems to grow wider every year, and it's not just on guns. However, the flames of distrust are stoked by the refusal of the legislature to let even a single year pass without another attempt at restricting rights. We would ask that our lawmakers attempt to rebuild lost trust by discontinuing their approach of focusing on guns and show their support for all Vermonters by helping them get the support that they need to make it through these very hard times. Now, this was going to conclude my remarks for today. However, I learned late last night that there's some other proposals on the table. One I'd specifically like to speak about is to whether or not to add a location to the list, another location to the list of places where carrying a gun is prohibited. And that is in places where alcohol is sold. And the point we'd like to make on that is that taking away everyone's right to carry a gun within a certain area because some people in that area are consuming alcohol is yet another example of the flawed approach that we think should be abandoned. What does this law do for someone who doesn't drink? A designated driver, a couple eating at a restaurant, someone staying in a hotel with a bar, outdoor and sporting events where alcohol is sold. There's a whole list of places that this can affect. In addition to being a political advocacy group, we're also a group dedicated to gun safety. Nobody is suggesting that we support drunk people waving guns around in public places. We do not support people behaving badly with guns. But to tell the whole population that their right to carry a gun depends on whether or not alcohol is served on the premises is to tell them that their rights and liberties do not depend on their own conduct, but on the behavior of the drunk and the lawless. A person's life does not get less valuable and therefore less worthy of defending because they crossed an imaginary line somewhere. Going from outside to inside, upstairs to downstairs, or from the street to the sidewalk should not be the difference in your right to carry your gun for your own protection. And we continue to oppose this bill in its entirety. And we ask that you would please vote no on H606. Thank you.
Thank you, Mr. Davis. Committee, any questions? Okay. Thank you. We'll be working on this bill over the course of a couple of weeks, and I'm sure you're aware of that. And let us know if you have any follow-up.
Yes, sir. Thank you. We'd be happy to come back if this continues to progress. So thank you.
All right, okay, we have Kim up next. So we've got a couple of minutes, so let's take did Kim say when she's gonna
No, but Hunter Jones is still waiting.
yeah, okay. All right, let's take a 5-minute break and just let Tucker know we'll come back. Kim,
But you have a coin? Maybe something like that.